Good evening. Welcome to the Tuesday, June 26th Planning Commission meeting. We are here tonight for an appeal, public hearing on the appeal of the Furtick Family Limited Partnership. It's file number PDT 17-4 and ARA 17-15. Thank you all for coming. Like I said, tonight we'll be holding a public hearing of the planned unit development that I just said. Okay. My name's John Borofsky, and I'm the chair of the Planning Commission. To start, I'd like each of the commissioners to introduce themselves.
I'm Bill Randall.
I'm Kristen Taylor.
I'm Stephen Baker.
And then staff, if you could identify yourself to the public.
My name is Dan Lawler. I'm an assistant planner.
Alyssa Hansen with the Planning Division.
Lauren Summers with the City Attorney's Office.
Thank you. I'd like to take a moment to explain who the Planning Commission is and our role. We are unpaid volunteers appointed by the City Council to 4-year terms on the Commission. We all live and work in Eugene, like many of you. We directly advise our City Council on matters related to land use, and we are also tasked with making certain land use decisions on behalf of the city. We're responsible for upholding the laws of our city and our state and the policies of the City Council. And of course, at the same time, we are responsible to everyone that lives and works in Eugene. We are at-large members, which means we have to consider the needs of the community as a whole, as well as the needs of all groups and neighborhoods. We are also human beings, which means each one of us has personal views that makes us who we are. But as planning commissioners, we are committed to balancing all of our needs as a community and making the best decisions we possibly can on our policies and our laws for us and future generations. We strive to sort through all of the evidence and facts presented and carefully review the pertinent land use code criteria in order to make thoroughly informed decisions as a governing body. This can be pretty tough to do, and we know not everyone will agree with every decision we make, but we do try to make these hard decisions through a careful deliberation and to the best of our abilities. The Planning Commission's role in this appeal process is to affirm, reverse, or modify the hearing's official decision granting conditional approval of the tentative PUD and adjustment review application. We will deliberate and take action on this item at future meetings, and the dates of that, I believe, is Tuesday the 2nd of, but we'll get back to you on the date of that.
You have those dates. But
Yeah, we have those, and we'll announce those later. It wasn't on my sheet. The decisions of the Planning Commission on this appeal is considered quasi-judicial decision. This means that we are legally required to have a certain order of speakers that we need to follow, and there are specific rules or criteria that our decisions must be based upon. First, we'll begin with a brief presentation from staff and then open the public hearing. If anyone in the audience would like to speak, please fill out a request to speak form and bring it forward to staff. Once the public hearing is open, speakers will be called in the following order: the applicant and those in support of the application. Second, those with a neutral position. And third, the neighborhood, appellant, and others opposed to the application. And then 4, staff responds to the testimony, and then we get the applicant's rebuttal to all the testimony. During this process, the Planning Commission may ask questions of anyone who provides public testimony. The Planning Commission's decision will be the final city decision on this matter. Since we have until July 7th to reach a decision on this application, we will only listen to testimony tonight. Deliberations and final action will take place at future public meetings. Any additional appeals filed regarding our decision will be brought to the State Land Use Board of Appeals. The purpose of tonight's hearing is to receive relevant testimony on the appeals issued before us. I want to remind everyone that your testimony must be directed towards the issues identified in the appeal statement and the applicable approval criteria from the Eugene Code. No new evidence, can be accepted by the Planning Commission, and we can only accept testimony related to evidence that is already in the record. What this means is that you should be testifying about the materials and information already presented to the hearings official in the first public hearings process, and whether or not you think the hearings official made a mistake based on the approval criteria for the tentative PUD and adjustment review, and the evidence he had at the time. I want to remind everyone that failure to raise an issue with sufficient specificity allow the Planning Commission and parties to respond will preclude future appeals on that issue. In other words, now is your opportunity to raise issues as clearly as you can so that the city and other parties can address them. Almost done. Before we begin, the Eugene Code also requires that planning commissioners disclose any conflicts of interest, ex parte contacts, biases, or abstentions. In a quasi-judicial proceeding like this one, the parties are entitled to an impartial or neutral decision maker. To ensure this fair consideration of the Eugene Code and the Planning Commission's rules, attempt to limit ex parte contact or communications between a party and the decision maker outside the public hearing process. Each planning commissioner must disclose and describe the substance of any communication they've had about this application outside the process. Planning commissioners must also disclose any potential conflicts of interest, that is, whether the decision they are about to make could or would result in a personal financial gain to themselves, their businesses, or members of their households. Finally, a planning commissioner cannot participate if he or she is biased. That is, for whatever reason, he or she is incapable of rendering a decision on the appeal. Do any commissioners have a conflict of interest or ex parte contact to disclose? I would just like to disclose that I am a board member of the Fairmont Neighborhood Association, and they are a party to this action, but I did not participate in any meetings or decisions by that body as in regards to this.
I'll add. I live within the Fairmont Neighborhood Association, but I have had no involvement, no ex parte communication. I know nothing about this application with the exception of what's in the record currently in my role as a planning commissioner.
All right. Does anyone in the audience or member of the commission wish to challenge the impartiality of any of the commissioners? Okay. Okay, staff presentation.
All right, thank you, commissioners, for taking the time out of your night to come here and preside over this public hearing. I'd also like to thank the public for coming out to provide testimony. Public participation is an integral part of land use application processes, and we value your input and strive to incorporate it into what we do. So what I'll be doing here today is taking you through a little presentation about the specifics of the Furtick PUD development, specifics as to site plan, the nature of the project, and then I'll provide a brief overview of the different issues that are up for appeal, although both the applicant and the appellant will go into greater detail about the issues of appeal. So this is the Furtick Family Limited Partnership. It's a tentative planned PUD under the needed housing track. There's also an adjustment review that's a part of the application process. This is a vicinity map of where the project would be taking place. It's bounded to the south by East 30th Avenue, the north by East 29th Avenue, Laurelwood Golf Course to the west, and other wooded and partially developed property to the east. It's within Eugene's urban growth boundary, and as you can see, there is a trail system to the north and coming through a city tax lot that is proposed as part of the project. Now, this is a rendering of the actual site plan of the project here. So I'll go through a couple different details of it to point out the nature of this project. So you can see we have 14 lots that are planned for single-family homes. We have 2 private streets that will be built on the developer's property in order to access these homes. On the top bound of the, and this is to the east, on the eastern portion of the developer's property, there is a city parcel known as tax lot 301. There is a proposed public street to be built and paved to access these different homes. And then to the north of tax lot 301 and where this proposed public street would go is a segment of gravel trail that connects out to 29th Avenue and the rest of the Ribbon Trail system. We can see on the northern part of the parcel, the shaded area represents slopes of greater than 20%. The open space tract that's proposed and required as a part of a needed housing tentative PUD is in the northern part of this area. Much of it is within the 20% slope and shaded space. You can also see to the west of the development and to the south of this parcel, we have a 30-foot conservation buffer zone. This is meant to preserve natural vegetation and areas surrounding the actual development. And yeah, so that's the general layout of what this project would look like. I wanted to go through a quick procedural timeline with everyone to make sure we're all oriented with where we are in the process of hearing this land use application and this appeal. On March 2nd, the application was deemed complete by city staff. On April 25th, we held a public hearing in front of the hearings official. On May 31st, the hearing official approved the application with conditions. And on June 13th, the Fairmont Neighbors Association timely filed an appeal to the hearings official decision. Then today, June 26th, we're holding this public hearing in front of the Planning Commission to determine whether the hearings official erred in making his decision. And then on here, I have July 3rd as the tentative date for Planning Commission deliberations. That has since changed.
And I'll clarify, we're leaving the 3rd, so just so everyone's clear, the first deliberations is July 3rd at 5:30 in the sloat room over at the Atrium Building. The second deliberation will be July 5th at 11:30 here in Harris Hall.
Thank you. And then July 7th is the date that a decision from the Planning Commission will be due on this appeal. So with that, I'll begin giving a brief overview of the different issues up for appeal, and there are 4 of them. And I'll begin by summarizing the relevant criteria that the hearings official used to make these determinations. So for appeal issue number 1, EC 9.83252 requires that proposed land uses and densities within the PUD be consistent with land use designations shown on the Metro Land Use Plan land use diagram and as refined in any applicable refinement plan, which in this case is the South Hill study. Appellants identify assignment of error 1 and appeal issue 1 as the hearings official erred regarding the applicability of the South Hill study to this needed housing PUD application by confining the scope of the SHS to relate only to the density of the proposed development. Appellants believe that the specific recommendations subheading of the South Hill study, which contains different policies and requirements for planning director decisions, should be applied to the application at hand, and they contend that this provision of code was not followed because of that. Appeal issue 2 regards EC 9.8325 sub 4. And so this provision has to do with tree preservation standards for PUDs. And so basically this code provision incorporates the tree preservation standards that are in EC 9.6880. And what that section of code requires is that the Planning Commission staff consider significant trees located adjacent to or within waterways or wetlands designated by the city for protection, as well as areas having greater than 25% slope. It also requires consideration of significant trees within a stand and individual significant trees. Appellants identify appeal issue number 2 as violating EC 9.83254 by saying there's insufficient evidence to sustain a finding that tree preservation standards were considered. And specifically what appellants claim is that the proposal evaluated different trees within the parcel that the PUD is proposed on, but that staff did not actually consider the preservation of the trees for trees in stands and individually significant trees. Appeal issue number 3 concerns EC 9.8325 sub 5. And this is a fairly straightforward code provision that prevents grading on portions of the development site that exceed 20% slope. Appellants believe that the hearings official erred in finding that the proposed PUD application satisfied this criterion. They identify specific actions like laying stormwater lines and wastewater lines, and argue that digging a trench and then filling the trench with after the line has been laid and leveling the top of that trench to a constant slope constitutes grading. And just as a little context, the code does not define grading. So the definition of grading is something that will be at issue and will be discussed further by both applicants and appellants. Appeal issue number 4 concerns EC 9.8325 sub 6. And what this code provision requires is that a proposed PUD implements safe and adequate transportation systems. It's another section of code that implements other sections of the Eugene Code, and specifically 9.6800 to 9.6875, which designate standards for streets, alleys, and public ways. So EC 9.6805, dedication of ways, requires that the city, it says that the city may require dedication of public ways for bicycle and pedestrian use, as well as for streets and alleys, provided that the city makes findings to demonstrate consistency with constitutional requirements. It also requires that the applicant conform with adopted street right-of-way maps. Appellant claims that, or argues that the proposed public street, which would be on city tax lot 301, is not adopted on the street right-of-way map. They also say that, or they argue that this piece of land is not designated as right-of-way and therefore should not be used for a public street. So that concludes my, oh, sorry about that. I skipped ahead a little bit. But yeah, basically the crux of the issue that appellants are arguing is that the lack of designation on the street right-of-way map essentially prevents the city from developing this parcel for a public street. So that concludes my brief overview of the appeal issues. Like I said, applicants and appellants will both go into greater detail about what the appeal issues are and what their beliefs on whether the hearings official erred or not are. So with that, I will turn it over to
Back to me.
Yeah.
Thank you. So now I'm going to, wait, before we open the public hearing, I just want to go over a few more procedural items. As previously mentioned, we have until July 7th to reach a decision on this appeal. For this reason, staff has reached out to the applicant and the appellant to discuss time limits, and it is my understanding that both parties have agreed to a 30-minute time limit for their presentation. I will also ask that individuals be limited to 3 minutes for testimony to allow everybody a chance to speak this evening. All right, now I would like to open the public hearing of the Eugene Planning Commission. And I've also said that we're going to do applicant and those in favor, neutral, and then those opposed. So we're going to start out with the applicant, which is being represented by Michael Reeder.
Good evening, Chair Borofsky, Planning Commission. My name is Mike Reeder. I represent the applicant, the Furtick Family Limited Partnership. First of all, I want to thank staff for the thorough job that they did in their presentation tonight, as well as in the agenda item summary. I appreciate the thoroughness for which they provided information to the public and to us. The only very minor comment that I would make is in the agenda item summary, it says that the applicants appeal focuses on 4 issues. Obviously, that's a scrivener's error. It should be the appellant. But other than that, we agree with pretty much everything that's said in the agenda item summary. Likewise, it probably comes as no surprise to the Planning Commission that we agree with the hearings official's decision. The hearings official got it right. Again, the only minor comment I would make in the hearings official's decision is that he suggested that I was the applicant's representative at the hearing. I was not. I was not at that hearing. I've been retained by the applicant since that hearing. The representative that was at that hearing was Renee Clough, who's here for any questions that you might have tonight. Also in the audience today is the owner of the property, Don Furtick. Mr. Furtick is turning 90 this year, and he's owned the property since the 60s. And when he purchased the property was vacant. The trees had already been logged, so the trees that you see on site there have grown since he's owned the property. He acquired the property with the intent of eventually developing it. Now his children are the age that he was when he acquired the property. And so here we are. So Mr. Furtick has owned the property essentially before all of the neighbors. So it should be understood that this property has been designated by the Metro Plan as low-density residential for many years, for decades, in fact. And my client has proposed to develop it at a density lower than the density that is spelled out in the South Hills study. So with those preliminary issues, I want to call your attention to a few of the handouts that are provided to you for tonight's hearing. The first one is enrolled Senate Bill 1051, as annotated by me and highlighted. It's the 2017 Oregon Laws, Chapter 745. We'll be discussing that tonight. A LUBA case, Parkview Terrace Development LLC versus City of Grants Pass, which I've annotated for you, as well as the code provisions of the planned unit development tentative plan. So this code provision that we're going to be looking at talks about the criteria for the needed housing planned unit development criteria, as well as looking at the difference between that and the general tentative planned unit development criteria. So you should have those. Also in the record are 2 letters from me, one dated May 9th on behalf of my client, that's in the record, and one dated May 16th, where we address a lot of the issues that have been raised in the 4 appeal statements that are before you tonight. So 3 of the appeal issues are legalistic in nature. It's really a matter of what does the law say, okay? There really isn't much dispute, if any dispute, about the facts. The 4th appeal issue really is an issue about the facts. What does the deed say about tax lot 301? And again, staff did a good job of delineating that issue. I guess it's an issue of law, although I don't really see from the appellant's point of view their legal position as to why tax lot 301 is not to be used for right-of-way purposes. But perhaps we'll hear from them, and I'll reserve the right to rebut whatever they say. But from my perspective, I can't even see the argument. So we'll talk about that a little bit. But first, what I'd like to do is I'd like to take us, if we start right, then we can go right. And the place to start is that this is a needed housing application. Okay, so what I've provided to you for your consideration to start right is Senate Bill 1051, which was passed by the Oregon legislature in 2017 and became effective August 15th, 2017. And what I'd like to do is turn your attention to pages 7 and 8. And if you go to the bottom of page 7, I'll walk you through what this provision states. Except as provided in subsection 6 of this section. Now, subsection 6 is the provision of the needed housing statute that allows an applicant to go under what the city calls the general standards. So the standards that allow you to apply subjective value-laden criteria. So if the applicant so chooses, they can go through that route. The city of Eugene has opted to establish legislation that allows for that alternative track. So that's what subsection 6 of this section is talking about. So it says, except as provided in subsection 6 of this section, a local government may adopt and apply only clear and objective standards, conditions, and procedures regulating the development of housing, including needed housing. The standards, conditions, and procedures may include, but are not limited to, one or more provisions regulating the density or height of a development, and B, may not have the effect, either in themselves or cumulatively, of discouraging needed housing through unreasonable cost or delay. So the item of significance here is that the needed housing statute was amended in 2017 to say that all housing in an urban growth boundary requires, unless an applicant so chooses to go under subsection 6, to be clear and objective standards. Okay, that's different because there was a lot of discussion earlier about whether or not this project is needed housing. Well, for sure it is, and I provided the hearings official legal justification for why market rate housing is considered needed housing. But even if the hearings official didn't accept that, and even if you don't accept that, state law makes that issue moot. So this is needed, this is an application for needed housing, but even if it's not, the city may only apply clear and objective standards because it's housing within an urban growth boundary. And so that's where we start, okay, is clear and objective standards. So what that means is, it means a few things, but one of the things that it means is that the standards that you apply, the criteria that you apply, must not be ambiguous. So whenever there's ambiguity, whenever you start talking about interpretation of the code, what you're doing is you're introducing ambiguity into the provisions of the city's code. And when you do that, that's violating the needed housing statute. And so it needs to be removed. So a case in point that you may be familiar with is the Walter case, right? The 19-lot rule where Luba found that the 19-lot rule had ambiguity, and because of that, Luba held that the 19-lot rule, even though it was in the code, is not applicable, okay? So that's where we start. Further, if you look on page 5 of the handout, Senate Bill 1051, there's further support for that proposition. It's on the top of the page. It's highlighted in yellow and red. It says, a city may not deny an application for a housing development located within the urban growth boundary if the development complies with clear and objective standards, including but not limited to clear and objective design standards contained in the city comprehensive plan or land use regulations. So it's clear under state statute and under case law that in this proceeding, we can only be looking at clear and objective standards. Additionally, the needed housing statute says something that is sometimes ignored in these proceedings, but those standards, conditions, and procedures must either of themselves or cumulatively not have the effect of discouraging needed housing through unreasonable cost and delay. So that's the other part of the needed housing statute that we need to be cognizant of. So before Senate Bill 1051 was adopted in 2017, case law was very clear that market rate, high-end luxury housing can be needed housing, and that's in the Rogue Valley Association of Realtors versus City of Ashland case. And again, as I said, now that point is moot because Senate Bill 1051 takes that issue out of case law and it's solidified in statute. So housing development cannot be subject to standards, conditions, and procedures that involve, quote, subjective value-laden analysis that are designed to balance or mitigate impacts of the development on adjoining properties and communities. And that statement is found in the Parkview Terrace Development LLC versus City of Grants Pass Luba case that I've provided to you. And what I did was, in that case, I highlighted there were 7 Grants Pass code provisions that were challenged by the applicant who was proposing needed housing. And in that case, the City of Grants Pass denied the application based on the City of Grants Pass code and essentially said that the application didn't meet these standards. And what happened was the developer who was the petitioner in this case went to Luba, and in front of Luba challenged those provisions of the Grants Pass code and said, look, these provisions of the code they violate the needed housing statute. So even though this code provision was a locally adopted code provision that was acknowledged by LCDC, it still violated the needed housing statute. And the reason why I bring this up is because you can look at these code provisions and look at them, and you can compare them to the Eugene code or the Eugene South Hill study, which the opponents, the appellants in this case, are suggesting apply in this case. Now, there is a code-based reason for why the South Hill study provisions, other than use and density, don't apply, and I'll walk you through that. But even if the code was silent on the issue or was affirmative on that issue, case law says that those value-laden, subjective, balancing, mitigating provisions of the code, or in this particular case, the refinement plan, are not to be applied in a needed housing case, okay? So Luba and the Court of Appeals have determined that ambiguous conditions and criteria that require interpretation are not clear and objective. So you can there's different ways in which a code provision cannot be clear and objective. One way is if it's a value-laden, subjective provision that requires balancing and mitigation. Okay, we're very familiar with those. The Planning Commission has to struggle with those issues all the time. Hearings officials have to struggle with them all the time. In the context of needed housing applications, you don't go there. Anytime you start to balance or mitigate, then you are in the violation of the needed housing statute, and you just don't go past that. Okay. Another way in which a code provision can violate the needed housing statute is when it is ambiguous, and there's more than one interpretation, and that happens quite often. And the Walter case is a prime example of where that happened in Eugene, where there was the interpretation. When you're interpreting the code, once you're interpreting the code, you are now outside of the needed housing arena. So if we go to the third handout that I provided to you, which is essentially it's just the code provision for plan unit development, and you compare the needed housing criteria with the general tract criteria. So if you let's first go to the third page, EC 9.832 sub 2. So when you're not in the needed housing tract, if you're in the general tract, or what the statute calls subsection 6, when you're in the subsection 6 arena, then you can have subjective, value-laden, ambiguous criteria that the Planning Commission gets paid the big bucks to analyze, okay? And so an example of that is subsection 2. The PUD is consistent with applicable adopted refinement plan policies. And as we know, many refinement plan policies are subjective, value-laden, require balancing, et cetera. So under the general track, PUDs can be evaluated. You can look at the refinement plan policies and weigh and balance the development against the policies, okay? Whoever drafted the Eugene Code Needed Housing Tract at least understood that provision that you can't do that under needed housing. So if you go to subsection 2 of 9.8325, which is a few pages in, let's see, they're not numbered, so I'll count. 3, 4, 6, the 6th page of the code, and you compare it to subsection 2 of the general tract, it says, the proposed land uses and densities within the PUD are consistent with the land use designations shown on the Metro Plan land use diagram as refined by any applicable refinement plan. So here's what this provision does not do. It does not kick in the South Hills study provisions other than the density requirement, which we are well under. The density requirement is, maximum density is 5, and I think we're at 2.9. And the land use, well, we're single-family residential in the low-density residential. So as far as I understand it, the South Hills study doesn't even have a land use diagram that would further refine the Metro Plan diagram. So that's a long way of saying that the code provision itself does not say what the appellants suggest it says. Okay, so in their issue number 1, where they're talking about the South Hills study, bringing in the policies of the South Hills study, that's inappropriate for 2 reasons. 1 is because the code doesn't require it, and 2, because even if the code required it, it would violate the needed housing statute. Okay, so that's appeal issue number 1. Appeal issue number 2 states that the hearings official erred in finding that 9.8325 sub 4 is satisfied as there is insufficient evidence to sustain a dispositive finding according to the applicable provisions. And then again, staff does a good job of kind of walking you through this. I would just add that not only did the applicant consider tree preservation as outlined in the written narrative and as outlined in this AIS, but even if they hadn't, those provisions themselves are not clear and objective and would have no bearing. Okay, so requiring an applicant to consider tree preservation is in and of itself an ambiguous and subjective exercise. We went through it, the applicant went through it, and it makes sense to do that. It makes sense from a practical marketing standpoint, but also to achieve the purposes of the code. But that code provision in and of itself is not clear and objective. Appeal issue number 3, the hearings official erred in finding that the proposed PUD does not run afoul of the prohibition on grading on slopes exceeding 20% contained in EC 9.8325 sub 5. And in this case, the hearings official decision states, goes through and analyzes and uses the dictionary definition of grading, which is what we as the applicant did as well. We look, if there's ambiguity and it's not defined in the code, then the next level of analysis is to look at the dictionary definition, which is what we did. What we said as the applicant is we reasoned that the Eugene Code does not define grading, it doesn't define excavating, but it makes a distinction. And I provided that to you in the record, and we can walk through that. But it's very clear that there's a difference between grading and excavating. And we agree with the interpretation of the hearings official that grading, in this particular case, the issue is whether or not we can put sanitary sewer through areas greater than 20% slope. Okay, and what we say is digging a trench and filling it, that's not grading. That's excavation. And the Eugene Code makes a distinction between those 2 events, okay, those 2 actions. So statute requires, when interpreting ordinances and statute, that you give effect to the meaning of different words. So since the city of Eugene has, in their code, made a distinction between grading and excavating, you cannot conflate the two and just say, well, any soil disturbance is grading and therefore you can't do it. That's simply not allowed under the rules of statutory construction as codified in the Oregon Revised Statutes and in case law. So we think the hearings official got it right. Lastly, the reason why it took so long to talk about needed housing and the needed housing statute and whether or not there's ambiguity, because even if we're wrong, even if the hearings official's wrong, even if staff's wrong, even if the applicant's wrong, that digging a trench for sanitary sewer and filling it is grading and not excavation, and there's no difference, that the fact that we have to interpret it means it's not clear and objective, meaning that that provision, the 20% slope prohibition for grading, is not allowed, just like in the Walter case when you had to interpret the 19 lot rule, okay? We're in the same arena. So for those reasons, the assignment of error number 3 should be dismissed. And lastly, the fourth assignment of error, as I said before, I don't even really understand their argument. It's clear that tax lot 301 was dedicated for right-of-way. We're proposing right-of-way. That's the whole point. And so I really don't understand what the factual or legal challenge is, but I suppose that we'll hear that from the opponents tonight. So with that, I reserve time for rebuttal, and I'd be happy to answer any questions that you have.
Any of the commission have any questions for Mr. Reeder? One comment that I would make is regarding these handouts. Mm-hmm. When we go into deliberation, we're going to have 3 new planning commissioners that are going to be deliberating on this. So if you wanted to make sure that they had highlighted ones of those, that might be helpful to get those to staff so that they've got the highlighted copies to pass out to the new commission members.
We'll be scanning those and forwarding them to everyone and all of you as well again. So, but you're welcome to submit additional copies.
Yeah, I provided 8 copies,
okay.
But I can also email those to you as well.
I just wanted to make sure that we're in a kind of a strange situation where new commissioners take office on July 1st, mm-hmm. and this is here, and our deliberations are after the 1st. So they have committed to watch this hearing and move on. So I just wanted to make sure that they had all the relevant materials. Thank you. Okay. I saw we got another one, but that wasn't opposed. I don't see anybody in the neutral. So then we'll move on to the opponent's representative, which is Charles Woodward.
Good evening, Commissioners. My name is Charles W. Woodward IV. My address is 44 West 35th, Eugene, Oregon 97405. I'm representing the appellants, Fairmont Neighbors Association, in this matter. Although the other issues presented in the appeal statement remain valid reasons requiring the reversal of the hearings official's decision, today I'm only going to address one issue, save us all a little bit of time, and that would be appeal issue number 3. The issue that I'd like to address concerns EC 9.8325 subsection 5, which states, as we've heard, there shall be no proposed grading on portions of the development site that meet or exceed the 20% slope. The applicant and the hearings official contend the code lacks a definition for the term grading, and thus they've endeavored to provide one for us, a definition that would conveniently allow the application to satisfy the code provision. Unfortunately, the definition the hearings official settles on introduces a discretionary element into a clear and objective standard. Indeed, in Walter v. City of Eugene, Luba stated that EC 9.8325 subsection 5 is, quote, a good example, unquote, of a clear and objective standard, quote, the purpose of which is to prevent development on steep slopes, end quote. In this decision, the hearings official has taken a stance contrary to the city's position on past appeals of this criterion. In footnote 6 of the Walter decision, the court notes that the city of Eugene took the position that the provision is, quote, intentionally rigid to ensure adequate protections related to erosion and slope failure, end quote. The hearings official's decision comments on this in footnote 4, stating that even if this is the purpose for the provision, the applicant's interpretation is not inconsistent with that purpose. Quote, under the applicant's interpretation, grading is much more likely to cause slope erosion or failure than merely installing underground lines and posts for housing, end quote. Allowing excavation, as the hearings official proposes, is nonsensical. In this instance, digging a trench for underground lines entails the destruction of tree roots and mechanical soil structure providing slope stability. This clearly and objectively violates the purpose of the provision and runs contrary to the express findings by LUBA that this is already a clear and objective standard. Furthermore, digging lines entails excavating to a grade, then grading the bottom of the trench to a consistent slope to ensure proper drainage of the lines. Then upon laying the lines, the trench is refilled. The refilling of the trench is complete when pre-existing grade line is attained. Manipulating the ground height to attain a certain grade is grading. The term grading encompasses excavation, filling, and any combination thereof. If you alter the grade, you are grading. This definition is common sense, clear and objective, and does not require an analysis of other provisions of the Eugene Code as the hearings official relies on in his decision. Again, LUBA has found this provision to be clear and objective. Counsel for the applicant states that a distinction between grading and an excavation in the code does not mean Counsel for the applicant states that a distinction between grading and excavation in the code, though there is a distinction, this does not mean that one includes the other. As counsel for the applicant stated, once interpretation is embarked upon when addressing factors, this is no longer a clear and objective standard. This is precisely what the hearings official has done in direct violation of the state statute. The hearings official has incorrectly manipulated a clear and objective standard preventing development on steep slopes to find satisfaction of EC 9.8325 subsection 5 and thereby erroneously approve the Furtick application. For this reason and those delineated in the appeal statement, the hearings official's decision should be reversed and the Furtick Family Limited Partnership Plan Unit Development application should be denied. Thank you for your time.
Any commissioners have any questions of this person? I have a question. You cited the LUBA case. Can you give me that again? I didn't get a chance to write it down.
Okay, it's Walter v. City of Eugene.
Eugene. Other people have any question of this person?
Did you include that within the record?
Yes, ma'am.
Thank you.
All right. With that, thank you for your testimony.
Thank you.
We have two people speaking against or opposed. Jason Brand and Jennifer Jorak? Jonak? Okay, so Jason is first. Unless Jennifer, you want to have somebody?
She actually provided her sheet first.
I'm sorry.
Might have
Okay, then
gotten
let's
out of
go with
order.
Jennifer first.
Can I have a PowerPoint to hopefully speed things up?
Oh, great.
Do you have flash drive?
It's already on there.
Oh, okay. Yeah, it is.
So should I just say next slide?
Yep, just let me know.
So it says Furtick PUD hearing on the desktop.
Yeah, it's bottom left down there.
Great, thank you. Can you go to the next slide?
Uh-oh.
Before you start, can you just state your name and your...
Yes, my name is Jennifer Jonak. My address is 2888 Arlene Way in Eugene. And I want to start by thanking the commission for their service. I know it's a volunteer activity. And I want to thank the city for its work as well. I'd like to address today my opposition to the PUD application and the decision based on error number 4 as identified in the appeal. And I believe the applicant's attorney here has said that he doesn't understand the legal basis for challenging the use of Lot 301 as a right-of-way. So I'd like to briefly address that. There's a trail on tax lot 301 that the city mentioned. This is the biggest issue, I think, both to myself as a neighbor and to most of the neighbors around this development. We're not opposed to development per se. The issue that we have is that this tax lot serves hundreds of hikers, dog walkers, and bicyclists. It has a public trail that was developed by EWEB in coordination with the city parks with the help of numerous volunteers. It's also a wildlife corridor. It provides green space and vegetation, and it's one of the only areas that bicyclists can use to commute back and forth to LCC. Hundreds of people use this every day. Next slide. This is a picture of it. As you can see, it is not currently a road. It is a trail. It is a hiking trail. Next slide. It shows up on city maps as part of the park system. Next slide. There are a variety of people who use it of all types. And it is important for wildlife to be able to access one green space to another green space. These are all priorities set forth in Eugene's Metro Plan. Next slide. In fact, even as recently as the May 2018 ballot measure, you can see in the highlighted blown up area, tax lot 301 shows up in that green area that is identified on the ballot measure as existing city-owned parks and other conserved lands. So this is something that's very important to the public, to neighbors, to myself and others. Next slide. The Furtick PUD would involve removing this trail and putting in a 30 or 35-foot wide asphalt road with streetlights. It would destroy numerous existing large trees. It would prevent wildlife from accessing one park space to another. Next slide. So as you can see, the experience you get from something like this is very different than what exists there now. Next slide. And the sad thing about this is destroying this trail is completely unnecessary. We do not begrudge Mr. Furtick the right to develop his private property. What we have an issue with is the use of a public resource for private gain. This access road that's proposed would benefit 14 single lots at the expense of hundreds and hundreds of people who use this trail every day and who have developed and maintained it at taxpayer expense. Next slide. The city claims that the tax lot 301 is a right-of-way, and we heard the applicant's attorney say the same thing. The only evidence that I have seen for this is the 1994 deed, which is part of the record. Yet there is an order, I have brought a certified copy of it with me, order number 94-12-719. This was the December 1994 order by which Lane County granted the tax lot to the city of Eugene. As part of this, the only restriction in the order is that lot 301 be used for a public purpose. And it cites to ORS 271.330, subsection 1. And that is exactly what that Oregon statute says. If one county, one governmental body is not using a piece of public property, it can relinquish it to another. Lane County originally bought this land to try to create a 30th Street interchange. When it decided that it was not going to do that, it wound up relinquishing this property to the city of Eugene. And the city of Eugene, next slide, has indeed used this lot for a public purpose. That has not involved a road. There has never been a dedication of this lot for public road or a designation as right-of-way. The only thing in it is the deed and this order, which indicates that it must be used for public purposes. In fact, if it had to be used as a road, as the applicant claims, then the use of this lot would not have been fulfilled over the past 20 years, and it would actually have reverted to Lane County, and I've cited the applicable case there. Next slide. Why is the city allowing this? This is what's so upsetting to us as neighbors. We believe that the public purpose under the code provision that I cited, the true public purpose is this as a public trail that benefits the entire community, not 14 wealthy individuals. Next slide. And as such, in the decision does not even weigh this. There is no finding that it meets a public purpose. If Mr. Furtick wants to develop this property, he can use his private property to do so. But without a public purpose in using this lot 301, he cannot appropriate a public trail and essentially take it away from all of the hikers just for his private development. And I've prepared a letter that I've given to the city which addresses this issue in greater length and cites some cases. And I will give to the city a certified copy of the order that I mentioned, along with the Oregon statute that allows the commission to take judicial notice of the order as an official government act.
Thank you. Next up is Jason. Yeah.
Does staff know, or the city attorney know, is this new evidence in the record? If you don't, I'm sure you'll assess that, but I just wanted to ask the question.
It's a good question, and we certainly will before our deliberations. We'll come prepared to talk to you on Tuesday.
Okay, thank you.
Hi, Jason Brown. You want to know where I live, right? 2986 Capitol Drive at the top of the hill. I'm here to speak really to two issues that relate to this as a concerned person who lives in the neighborhood and as a member of the Eugene, public and as a taxpayer. The first has to do with what Jennifer raised, and that is, I think it's lot 301, the access lot. My understanding is that the Furtick development is able to access their property through their own land and doesn't need the the city lot 301 in order to access their development. And so I'm sure that legal arguments can be made if arguing why the city has the right to give that lot to the developer. The question is, to me, morally, whether they should do that. It's been used now for 10 years as a hiking trail, or 8 years at least. Community members have devoted their time and resources to building that trail after the city promised them that they'd be able to keep that trail. The trail, that lot is a public resource. It was purchased, ultimately tax dollars went into that lot, and it's being given essentially to a private developer. Now, it would be a completely different issue if the developer's property was landlocked, but it's not. It's a matter of the scale of profit for the developer. They will obviously have more profit if the city gives them this lot. If they don't give them this lot, they might have slightly less profit, but the trail system will be much more robust and healthy, and essentially the citizens of Eugene won't be robbed. And so to me, my greatest concern is the relationship of the citizens of this town and the city to its government, and to the planning department, to the commission, and to the city council. The other issue to me is the needed housing. Listening to the applicant argue that this belongs in needed housing, I mean, to me, is just ridiculous, frankly. The argument seems to be that anything from a doghouse to an 8,000 square foot mansion can be needed housing. The reference to Ashland, the Ashland case, the city specifically outlined what they required for needed housing, and it did in that case require some high-end housing. The city of Eugene has never outlined that to that level of specificity, what needed housing is required for this city. And they certainly never have laid out that they require housing for the wealthy. Whenever needed housing is brought up in the city, by the city, or in the literature or in the codes, it refers to housing that's needed for the middle and the lower income. It's quite obvious that all the housing in this case is going to be for the wealthy. So it seems to me that if this is interpreted as needed housing, it is transparently a way to sort of obviate the protections afforded for the other track, the normal track of development in which refinement plans apply. And so if we're going to go down that road, you're essentially tossing out refinement plans in favor of using the needed housing track to give developers a free hand in doing whatever they want. And so the last question I have is it too late to, I came 15 minutes late, is it too late to, there's a phase in the beginning in which we question the objectivity of members of the commission. We're past that, right?
Well, we did say it, but there's always an opportunity for that.
Okay, well, there's something I'd like to enter into the record. Can I have that, Jennifer, those pages? This is an email trail that was part of the record for the
Hand it over here. Yeah.
in which Tiffany Edwards described her feelings about neighborhood movements and NIMBY, and to me it brings into question her ability to be an impartial member of this commission. So I would object to her playing any role in this this hearing or this this procedure, because I think the email chain that I've entered into the record demonstrates that she has an ideological objection to neighborhood involvement and trying to uphold the codes. Thank you.
Thank you. All right, I've got one more person that has signed up, Larry Weinerman.
If I may, Chairperson.
Yes.
Just to be clear, again, for the commission and for the audience, this is an on-the-record appeal of the hearings official's decision. The Planning Commission, the record is closed to new evidence. The Planning Commission cannot accept new evidence. You can listen to argument based on evidence that was provided to the hearings official, but if something was not provided to the hearings official, the Planning Commission cannot consider it. So I just want to be clear about that.
Will that have to do with challenging the commissioner's impartiality?
Well, it's my suspicion that the email trail is not included in the record that was before the hearings official. And technically, Tiffany Edwards has not yet been seated on the Planning Commission. So.
Okay.
So you once again, you're going to go through that after you've had a chance to evaluate not just that, but any other things of the record prior to deliberations?
Correct.
Thank you.
And I'll ask another question. Go ahead.
My name
Larry.
is Larry Weineman. I live at 2891 Central Boulevard, and I did testify in front of the hearings official on this matter and others, and I gave in written testimony. So I wanted to talk about...
Mr. Weinerman, could you speak into the microphone so
Thank you.
everyone can hear you, please?
So I wanted to testify about number 9.88325, PUD needed housing. The applicant's attorney defined grading, which is really interesting. If you look at the statute, it specifically says needed housing. It just doesn't say housing. If it said housing, that would indicate all housing. It says needed housing. I think if you look at the case law, you will see that there are different cases that have different outcomes. I strongly encourage you to look at what you define as needed housing. It can't be just huge houses. And so that's the only thing I want to put in front of you today. And like I said, I did testify in front of the hearings official about this and lots of other things. And I also handed it in written. Thank you.
Thank you. And we have Sean Malone.
Good evening. Sean Malone on behalf of the appellants. Really just wanted to speak briefly on the 20% slope issue. This hearing's rather important because essentially what we have on the table on the chopping block now is that standard from here on out. If the Planning Commission agrees with the hearings official, that particular provision, in my opinion, one of the backbones of the needed housing track criteria, will be gone. Development will now be allowed to take place on whatever slope an applicant would like. That's because the hearings official interjected this sort of ambiguity in what has otherwise been determined by LUBA and others to be a clear and objective standard. If you're moving dirt on 20% or greater slopes, then you're violating that code provision. That's what makes it clear and objective. But if we sit here and try to guess at whether grading entails excavation or vice versa, then you've already lost that standard because it becomes discretionary. It then would entail interpretation. And we won't have that standard at all in our code anymore when it comes to PUDs because we've inserted some sort of manufactured interpretational sort of discretionary issue into that standard. And then if we look to the purpose of that standard, which is to prevent erosion, ensure slope stability, then what would be the rationale in digging a giant hole on something that's 20% or greater, but not allowing you to just grade it? Now that just simply doesn't make any sense. And what LUBA is going to look at later on is whether what the Planning Commission does, how they're looking at these provisions, is consistent not only with its text, but the context, but the reasons behind the particular provision. And it makes no sense whatsoever to allow a developer to dig some giant hole, which I'm assuming is what we're all thinking excavation is, something worse than grading in place of this provision. So the plain text of it is no grading 20% or greater. That is violated once you start excavating. If you are excavating at all, you're going to be engaging in some grading somehow. That's just the reality of it. And LUBA's already wrestled with this and come out on the side opposite of the hearings official. So I would very much encourage the Planning Commission to retain this important provision in their code by going with the sort of clear and objective route on it instead of following the hearings official down this sort of interpretational hole. And it's my sort of opinion that the Walter case came out against the city of Eugene and the same hearings official in a manner that was not so great. And the hearings official was obviously cognizant of that and a little worried about going down that same road again. But here, you don't have to have, there shouldn't be any worries because LUBA's already spoken to this issue, and it should remain clear and objective, and it should remain part of the code because it's very important.
Thank you.
Thank you.
I don't have any more green slips. Is there anybody else that wished to testify that didn't fill one out? Okay, then. Any commissioners have any questions of the people who testified? All right. Then the next thing we have is staff comments.
Staff has no comments at this time.
All right. Then we have the applicant's final rebuttal.
Good evening. For the record, again, Mike Reeder for the applicant. With me is Renee Clough, the applicant's representative, as well with Branch Engineering. And I wanted to respond to some of the comments that were made. First, the easy one is the question about needed housing, whether or not market rate housing is needed housing. As I provided to you the statute has been amended since the case law, since the Walter case, since the Grants Pass, the Parkview Terrace case has come out to make it clear that all housing in the urban growth boundary is subject to clear and objective standards. There's no ambiguity there. So whether or not the opponents agree with the holdings of the case law that interpreted the previous needed housing statute, that's irrelevant. The statute is, the legislature took care of that. And the reason that it was changed was to prevent this type of anti-housing behavior in these particular cases. So let's talk about if you could go back to the deed. Respond to appeal issue number 4, which is what the purpose of tax lot 301 is all about. Because we've heard a lot about the fact that it's been used as a trail by hikers, et cetera. Well, the deed is pretty clear. I don't see any ambiguity here, and it's in the record. And it says, I'm not going to read the whole deed, but the pertinent part says the city, by acceptance of this grant, and this grant was from Lane County, and I'll talk about that in a little bit, but by acceptance of this grant hereby declares that it has full knowledge of the subject real property conveyed by this grant was acquired with road funds of Lane County, and hereby accepts the legal obligations and restrictions of use of the property for public road purposes as provided for under Oregon law in this grant. Now, I have not had the ability to review what was submitted into the record, and I would actually appreciate a copy if you can provide that to me. That was provided to you by the appellant so that we could respond to that. But in any case, the deed is clear that tax lot 301 is held by the public. In this particular case, it's the city of Eugene, and it's for road purposes. So to suggest that this is being appropriated by the developer is complete nonsense, and it's actually pretty offensive. So let's talk about the Walter case, Walter versus City of Eugene. There was a reference to footnote 6 in that case where there's a suggestion that the appeal issue number 3 regarding grading, that's a settled issue, that the 20% slope issue and grading issue, that's been settled by LUBA. That is certainly not the case. The Walter case did not say that there was no ambiguity in what the definition of grading is. It didn't approach the question. What it said was that when you calculate the grade, that as applied, that standard is clear and objective. There was no discussion. It wasn't an issue in Walter as to whether or not excavating was grading. Again, and I would go back to the case law that I cited to you, which is that when there's ambiguity, that is not a clear and objective standard, and therefore it violates the needed housing statute. Should also be noted that the application is not dependent on any development, or in this particular case, excavating in the 20% slope. In the record, we have, and I'll turn a little bit of time over to Renee Clough to explain what's in the record, but we show that we have sanitary sewer on the site plan that's already in existence. So even though we don't believe that the appellant's argument has merit for a couple of reasons, we're not reliant on using the 20% slope.
Hi. So on the first sheet, the existing condition sheet of the plan set, take note that on the east side of Spring Boulevard, there was a previously approved 2-parcel partition, PT 17007, and there is already an approved PEPI, privately engineered public improvements plan, for the construction of street improvements and a wastewater sewer in Spring Boulevard associated with that partition, and that is shown on the existing conditions plan. These parcels, lots of the PUD could alternatively connect to that wastewater line that's in Spring Boulevard with nothing going through a 20% slope.
So can I ask a question?
Let them finish their presentation, then we'll have time for questions.
Thank you. I heard Mr. Malone in talking regarding the grading issue talk about the text and the context of grading and the reasons and the purpose behind the 20% slope issue. There is no legislative history whatsoever on the purpose of that that provision, the 20% slope. You can use logic and you can provide an explanation, which the opponents have provided, but that logic can be rebutted. And when you're talking about text and context, that is, what you're doing is you are engaging in interpretation. And when you engage in interpretation, that is not a clear and objective standard, and therefore you can't consider it. Specifically talking about the motives of the hearings official, about not wanting to, looking at what happened in the Walter case and not wanting to, well, I don't want to put words in the mouth of Mr. Malone, but what I understood him to say was that somehow the hearings official made the decision that grading, the excavation was not grading, somehow had to do with the Walter decision. There's nothing in the record to suggest that, and that's just pure speculation. Do you have a copy of that order that was provided to you by one of the opponents? Because we have a short turnaround, I'd like to take a look at that and provide a response. Sure. Perhaps that would be a good opportunity for Ms. Taylor to ask questions of Ms. Clough.
So I just want to get a clarification on what you were saying. So in terms of you've got proposed excavation for utility within the 20%, but you're saying that alternatively, it's not necessary that there is an alternate location.
Correct. Our preference would be to put in the sanitary sewer laterals as shown on the plan. However, if a condition of approval comes out that the lots need to connect up to that sanitary sewer in Spring Boulevard, that is an option.
Okay.
The reason for our preference is, as you can see, the site slopes away from Spring Boulevard, and so then we would have to have pumps, which can fail, and not everybody wants a failed sewer pump. So our preference was to not do that.
Okay, great. Thank you.
I want to raise an objection to that. If the applicant's proposing to change the application.
This is the rebuttal's time.
You're allowed to raise an objection at any time, as far as I'm concerned. I'm just objecting to the fact that it appears the application is being changed at this point in time, and we need notice, and we need an opportunity to respond to that change.
Well, if that's a consideration of the opponent, then I would strongly suggest that you really consider the fact that when there's interpretation, we are talking about something that's not clear and objective. So we're confident in that position, but I wanted to give the Planning Commission the opportunity to have an alternative. But we're confident that if we went to LUBA on the appeal issue number 3, that we would prevail, and that we would prevail on all 4. In fact, what happened in the Walter case was the Land Use Board of Appeals reversed the city's denial, not just remanded, but reversed it and awarded attorney fees to the applicant. We see this as no different. We have 4 appeal issues, all of which have no merit, and that we feel confident that if we went to LUBA that we would prevail and we would be reversed. And I've never actually uttered those words to a planning commission before, so I feel strongly about this particular case, and I just wanted you to be aware of that. What I will do is I'm going to just briefly, this is a very brief order, give me just a moment.
We'll give you a few minutes since
Sure.
it was
Thank you.
something you haven't seen, and that the record is, or that we are in such a tight time frame.
Could I ask a question of staff?
Sure.
2 questions I have, and for our deliberations, since the record does have close to 1,000 pages in it, could you, for our deliberations, locate for us the existing conditions plan that Renee was talking about, what page that's on for us, as well as the deed, where that is in the record? That would be real helpful to have those page numbers to be able to find it. I'm scrolling through it here and I'm not finding it at the moment.
The page number for the deed?
Yeah.
It's,
We don't need it this
You
instant.
don't need, I don't need
That's
it right
fine.
now, but
For deliberations.
just for our deliberations, that and the existing conditions plan that Renee was talking about. That'd be helpful.
Thank you. So now that I've had an opportunity to review this order 94-12-7-19, in the matter of authorizing relinquishment of county-owned road fund property to the city of Eugene under ORS 271.330 sub 1. I have no objection to this being submitted into the record. I don't want that to be an appeal issue. I have no objection. And in fact, this actually supports our statement. So what it says is we've got some recitals here, and this is actually very helpful to our position. It says, whereas the city of Eugene has requested relinquishment of county-owned real property for public purposes, and whereas ORS 271.3301 sub 1 provides for the relinquishment of title to the property not needed for public use to other government bodies in the state of Oregon, and whereas property relinquished to another governmental body under ORS 271.330 sub 1 shall be used by that governmental body for a public purpose. And whereas the subject real property proposed to be relinquished is an asset acquired with road funds. And whereas the real property described in Exhibit B attached and incorporated herein, and I'm assuming without reading the deed that we're talking about tax lot 301, I'll just put that caveat out there, herein is not needed for public purposes. Therefore, it be ordered that Lane County authorizes the relinquishment of real property described in Exhibit B to the city of Eugene via quitclaim deed. So what this says to me is that using the road, using tax lot 301 for a road is a public purpose. By definition, that is, a public road is a public purpose. The property could be acquired by the city of Eugene through the power of eminent domain for a road. Okay, it doesn't say anything about it being used for trails or for parks or any other purpose. And then what it does is it says the recital says that it was relinquished as an asset acquired with road funds. And if you look at the deed that I quoted to you earlier, the deed shows that the purpose of relinquishment from Lane County to the city of Eugene was for road purposes. So there's no incongruity with this order and the deed. And this is actually supportive of our case.
Anything else on rebuttal?
One very brief point. One of the opponents said that the ballot measure map showed the green portion of that area, tax lot 301, as being for parks. But that ballot measure has no legal effect on whether or not tax lot 301 is to be used for parks or for any other purpose. It's the deed and the order that controls. Thank you.
Any questions from commission? All right. With that, I'm going to close.
I just need to put my objection into the microphone here for the record. So, to the extent, so I can preserve a procedural error before LUBA related to this, it sounds like to me the application just changed right there. As a result, the city needs to provide notice to folks and allow them the opportunity to respond. That's essentially how you cure a change in an application. So my objection's on the record. Thank you.
All right, with that, I'm going to close the public hearing.
If you would, Chair Borowski, I'll respond to that. If that is the position of the opponents, then we withdraw our conditional change of the application. I think you have the power to do it. It's all in the record shows that there is another line. We don't think it's necessary. We thought it might be helpful to the Planning Commission, but in this particular case, it's not worth that being an appeal item at LUBA, so we withdraw that. Thank you.
Thank you.
All right, I am going to close the public hearing. At this point, now we will talk to staff. If there's anything staff would like to tell us.
Thank you, Commissioner Borowski. As you've heard, there are some procedural issues that have come up tonight. Staff will need a little bit of time to process those, but we will be prepared to talk to you about them on the 3rd when it's time for deliberations.
Mm-hmm.
Okay. For me, one of the ones will be as far as the strange issue of seating new commissioners and the opportunity to challenge their impartiality would be something that I would be looking forward to hearing at that.
Well, yes, We do have a challenge on the record. I anticipate that what I would do is ask Commissioner Edwards, when she becomes Commissioner Edwards, if she feels like she can make an unbiased decision on the application, and she will have the opportunity to respond to that question.
So and it's not just Commissioner Edwards, it'll be the other, all the new commissioners. At that point, we'll be asking if they have any ex parte contacts. Will there be an opportunity for people to challenge that since the hearing is closed? That's my question. Not just this particular person, but any challenge of bias.
It's a good question. If any of the new planning commissioners do have ex parte contacts, then yes, the parties would need to have the opportunity to respond to those ex parte contacts. So we'll cross that bridge when we come to it.
Yeah, I just wanted to make sure that the people who are in the audience know that at our deliberations, we are going to have newly seated commissioners, that we haven't asked that question that was asked of us at the beginning of this hearing. So it sounds to me like we will ask them that question before we start deliberations, and people will have an opportunity to challenge them or whatever the procedure is. Does that sound correct?
We will have to figure out how that will work, but.
Okay, all right. I don't know it. She's not certain. She's going to do some research on it, but just know that that's out there. Any other questions for staff? Commissioner Baker, then Commissioner.
Yes, it was mentioned by staff of a 25% requirement, but I didn't note that is any part of the site 25% or greater slope?
20%.
No, there was 20 and 25. There were two different.
We'll have to look, I think, in the record to find that information.
Okay, and if staff could make it clear on that drawing what parts are, there's sort of grading on one direction. Are we talking only about this one section here? That's the 20% slope on the left?
That's so correct. The proposed activity in that area would be on the northern portion of the site in the shaded area.
But I just wanted to make sure because the drawings and the shading is a little
Right, so that
confusing.
particular shading that's at the northernmost end
Right, I
on
just
that
wanted
open
to-
space
so-
lot that represents the 20% or greater.
Yeah.
The shading around the edge, my understanding the 30-foot buffer.
Okay, well, maybe staff could sort of color it in a little bit to make it clear so we know what we're talking about. Thank you.
We can do that.
I would change that.
Yeah. Just reference the documents in the conversation.
We'll bring full site plans if you
Yeah.
need to look at those for clarity.
All right, Mr. Taylor?
So I have a question about, Mike Reeder had made a comment in his initial testimony about the code being, there's some clarity or differentiation between grading and excavating, and I just want to make sure, if that's in the record, if you can just, you were going to talk about pages within the record, Commissioner Randall's, if that's something you can highlight, I'd appreciate that.
We can do that.
Yeah, we can do that.
And then this may go without saying, but the new or maybe the information that's been presented tonight, you'll go through to make sure that is in the record, and if not, then we'll not receive that. Is that?
Yes, we will, we'll do that analysis, and then if indeed the new evidence has been presented tonight, we will come back to you and ask you whether you want to reject it or reopen the record, which, given the tight timeline, would be difficult.
Okay.
Oh,
Commissioner Baker, then Commissioner.
Yeah, I think it's really moot, but I just wanted to clarify. I noted that the South Hills study is cited under the section with some criteria under the section for tentative plan new development approval criteria needed housing. And I believe that's where we have this, but there's several provisions there that are cited. regarding the South Hill study. And I assume that that's part of the,
Commissioner Baker, can you point us to the page that you're looking at?
well, it's 9.5, 9.8.5 9.8325, section 12.
And what's your question about it?
Well, just clarification for what the,
Commissioner Baker, I would just point out that as far as I understand, that particular approval criterion is not included in any of the appeal issues.
right, but I just wanted to clarify that the South Hill study is mentioned under the needed housing.
Oh, I see.
Got it.
Commissioner Taylor.
So I just want a clarification, just because of what you just said, which is, I thought it was my understanding. So for instance, if Order 9412, that Mike Rader just said that he doesn't have any objections if it is new in the record, essentially, even if both are okay, Jennifer and Mike are both okay, if we accept it, we open the record, even though they're both okay with it, if it is new evidence.
I will be more prepared to speak to you about that on
Perfect.
Tuesday.
Thank you. You've already said that. Thank you.
Yes.
And then just one more, as far as the information that Mr. Reeder gave us on the LUBA ruling and the Senate Bill 1051, since those are already out there, is that's not necessarily new evidence?
Not this.
I
mean,
don't
obviously,
have-
the city code
The
is
code, I
part,
don't
is
know
not a
for
problem.
that. Yeah.
But I just wanted to make sure if
Do you want it back?
a highlighted copy of Senate Bill 1051 and that,
I would
if
say,
that,
yeah, to be safe, we'll collect those from you tonight, and then we can make a final decision about those on Tuesday as well.
okay.
Well, okay. It would be nice if we could have the decision on whether or not we can, because we're going to be looking at this before Tuesday. So if there's a decision that these are allowed,
Well, the planning commission has to make that decision, so we would need to wait for our meeting.
Isn't it up to our legal counsel to tell us whether these are new in the record?
I can give you my opinion.
Right.
But planning commission needs to make the decision whether to accept or reject materials.
Do you have an opinion now? I know that's putting you on the spot. It would be helpful if you did.
I will say that generally statutory pages I would not be too concerned about. However, these are highlighted, and that makes it a little bit of a closer question.
It was
I haven't-
part of why
I mean-
I asked, and I know I have a copy of Senate Bill 1051 already. I mean, for other reasons. But
To be able to give you the best legal advice, I'd like to take the time to do the research that I need to do and come back and talk to you about it on Tuesday. I understand it's a tight timeline, and I'm sorry that the commission is put in this position, but I feel like I will be best prepared to talk to you on Tuesday.
could you give us comfort in collecting this, but letting us know that Senate Bill 1051, since it is a legal state law out there, is fair game if we chose to do anything on our own, or is that?
I would like to collect it from you. I think that, I will just say kind of again, remember this is an on-the-record appeal, so you are looking at things that were provided to the hearings official. I'm not aware that a copy of Senate Bill 1051 has been included in the record. It may be, but that's what I'm going to ask staff for help with in combing through the record before Tuesday.
so then I have I'm going to put myself in the queue. So I have a question. There was a LUBA decision that was referenced several times, the Walter versus the city of Eugene. Do we know if that is in the record?
That is in.
Okay, so we can dive into that LUBA decision over the weekend while we're studying our packet.
as part of the record.
Yes, okay. Commissioner Baker.
Yeah, two questions. Can you also comment on whether the Parkview Terrace LLC versus Grants Pass is in the record?
I don't know the answer to that.
Okay, so you'll get back to us on that one. And then on Senate Bill 1051, wouldn't this only be appropriate when it was adopted and went into law related to when the application was filed? And in that case, would you confirm for us that it went into, it wasn't just an enrolled bill, but it actually went into law, before the application, before the application was filed? Because it would be.
Confirm that the portions of Senate Bill 1051 that affect ORS 197, 303, and 307, which are the needed housing statutes, took effect prior to submittal of this application.
Okay, that's all I
Concern would
wanted.
be if that was part of the record before the hearing's official, because if it wasn't, then it's really not part of our purview. Okay.
All right. Other questions for staff? Okay. I would like to thank everybody for coming out tonight and for putting up with the tight timeline that we're under here, and also the fact that this decision is straddling commission terms. So I appreciate you guys bearing with us on any stumblings that we have going along the way. This is our normal procedure. So with that, the meeting's closed. Thank you.
I just want to say something to the group that Commissioner Borofsky had noted. Tiffany Edwards, Commissioner, when she does become commissioner, she is in the back. The other two commissioners, just so you know there isn't going to be a blip, they are going to review this hearing and be prepared to deliberate. So it doesn't mean they're going to show up on the first day and know nothing about this project.
Yep. All right. Thank you.